My half-brother Signed my father's orchard over to himself while Dad was still sedated. He didn't know I'm a certified document examiner. I've spent 12 years as a board-certified forensic document examiner, the person courts call when they need to know whether a signature is real or whether somebody just wanted it to look that way. My father is alive, resting in a recliner 40 minutes from the orchard he's owned for 45 years, and the half-brother he met 4 months ago had already notarized a deed moving the whole property into his own name, while Dad was still coming out of sedation from a heart procedure. 6 days, that's what I had before that deed finished processing, and $2,180,000 of my family's land became legally, permanently his. My father, Jerry, has run Kessler Family Orchard since 1979, 42 acres his own father Frank cleared and planted starting in 1958. 3 generations of the same rows of Honeycrisp and Northern Spy, and the old Baldwin trees nobody plants anymore because they don't ship well, which was never the point of keeping them. Frank built the original farmhouse himself, board by board, on weekends he could have spent doing anything else, and carved the wooden sign that still hangs over the barn door, Kessler Orchard, EST. 1958, in letters a little uneven on the left side where the chisel slipped once, and he decided fixing it would matter less than finishing the job. Jerry added the cider barn in the 80s and the little tasting room in the 90s. And by the time I was old enough to remember any of it, the whole operation ran on a rhythm so steady you could set a season by it. Bloom in May, white and pink covering 42 acres in a single week that always felt too short. Thinning in June, culling half a tree's fruit so the rest would size properly, work that looked wasteful to anyone who didn't understand it. The first drops in August that meant cider pressing had started, and harvest crews by September, the smell of crushed apples thick enough to taste in the back of your throat from the road a quarter-mile out. I grew up on that land the way some kids grow up in a family business that never once felt like a business, because nobody around me ever called it that. I drove a tractor before I could see over the dash without a cushion Dad rigged out of a folded feed sack. I learned to tell a Honeycrisp's ripeness by smell before anyone taught me to read a Brix meter, standing next to him in a row while he broke a fruit open, and had me guess the sugar content before he'd let me look at the refractometer. And by the time I was in high school, I could walk a row and tell him which trees needed attention before he'd even asked. He wasn't a demonstrative man. He showed you what mattered by handing you the job that mattered. And the September I turned 16, he handed me the harvest crew's whole schedule, 12 seasonal workers and a picking window that couldn't slip more than 2 days without losing fruit, and walked away without a word of instruction. That was as close to a declaration of love as I ever got from him, and close enough that I never once doubted it. There's one harvest I still think about more than any other. The September I was 11, Mom still alive, the whole crew running behind because of an early frost scare, and Dad let me ride in the bin truck instead of school for 2 full days because he needed hands more than he needed attendance records. Mom argued with him about it at dinner that first night, not really angry, more amused than anything. And he told her the trees didn't care what grade I was in, and she let it go because she could see how much it meant to both of us. I can still find that exact bin truck's gear shift with my eyes closed. I couldn't tell you a single thing I learned in school that same week. The tasting room itself was always more my mother's project than my father's. 4 tables and a counter Dad built from a fallen walnut tree on the property. And growing up, I spent as many Saturday afternoons pouring samples for tourists as I did picking fruit. Mom kept the guest book by the register, a real notebook, not a screen, and she used to make me read a few entries out loud to her most weekends. Said it was good practice for a kid who talked too fast to slow down and actually look at what was in front of her. I didn't know yet that slowing down to actually look at what was in front of me was going to become the whole shape of my adult life. Dad also taught me, almost as an aside, how to read the paperwork side of the orchard business long before I ever thought about a career built on paper. He kept every equipment title, every insurance rider, every county assessment in a single fireproof filing cabinet in the barn office, organized by year. And some winters when there wasn't fieldwork to do, he'd have me help him refile things. teaching me without ever calling it teaching that the paper trail behind a piece of property mattered as much as the property itself. I didn't connect that memory to what happened years later until I was already standing at Dale Whitcomb's counter with a deed in my hands. I think about it often now. I didn't stay in the orchard business myself. I went a different direction entirely, into forensic document examination, a field I fell into almost by accident during a college internship at a regional crime lab, sorting evidence intake for a woman named Doris Kowalczyk, who examined question signatures for a living and let me sit in on casework nobody thought to keep from an intern. My first real catch, 6 weeks into that internship, was a forged endorsement on the back of a stolen check, a signature that looked convincing to every untrained eye in the building, until Doris showed me how the pen had lifted 3 separate times in places a real signer's hand would have kept moving. I've chased that same specific feeling for 20 years since, the moment a document that's been lying to everyone finally stops lying to you specifically. I spent 6 years in a private lab after that doing casework for banks and insurance companies before I went independent. And Dad never once made me feel like leaving the orchard behind was any kind of departure. He used to tell people at the farmer's market that his daughter caught liars for a living, said it with more pride than he ever managed to put into a sentence about the orchard itself, which used to embarrass me a little until I understood what he actually meant by it. He'd spent his whole life building something with his hands that people could see and touch, rose and bloom and fruit you could hold. I'd built something people mostly couldn't see at all, and it mattered to him more than I think either of us said out loud that somebody in the family had. My own marriage ended 9 years ago. Quietly, no children, no real villain in it either, just 2 people who wanted different versions of a life and finally admitted it out loud instead of pretending otherwise for another decade. I mention it only because it meant that by the time Dad started needing more of my Saturdays, there wasn't anyone at home keeping score of how many of them I gave away, which made it easier to be the one who showed up without ever having to negotiate it with anybody but myself. My mother, Lorraine, died 5 years ago on an icy bridge 11 minutes from the house, a patch of black ice she'd driven over 1,000 times without incident. And the last thing anyone in my family said to her was something about picking up cider jugs from the printer for the fall labels. Dad didn't handle the silence afterward well. He kept her reading chair exactly where it had always sat in the front room, and for the better part of a year he set 2 coffee cups out most mornings out of pure habit before he caught himself and put the second one back in the cupboard. I live 35 minutes from the orchard, close enough to drive out most weekends without it costing me a full day. And I did, coffee in hand, walking the same rows I'd learned to read as a kid. Except now the conversation had shifted from what needed pruning to which parts of the operation he could still manage on his own, and which parts he was starting to hand off without ever saying so directly. There was a Saturday, maybe 2 years after Mom died, when I found him sitting on an overturned crate halfway down the northern spy row, not hurt, just resting longer than a man his age usually needs to. And when I asked if he was all right, he told me his knees had started sending him memos his brain didn't much care for. He let me start walking harvest with him after that instead of trailing behind at a polite distance, the same way he'd once let me run the crew schedule at 16, a small surrender dressed up as company. He was 74, healthy enough by most measures, but he'd started catching his breath mid-row more than he used to, waving it off every single time I asked. He finally mentioned it to his cardiologist, that spring chest tightness he'd been quietly calling heartburn for months, and came out of that appointment with a scheduled cardiac catheterization, a same-day procedure to check for blockage, nothing his doctor described as urgent. I didn't know yet how much the specific day of that procedure was going to matter. Watching a parent's body start setting its own limits, quietly, one small refusal at a time, isn't fear exactly. It's closer to noticing a fence line has shifted somewhere out past where you usually walk, and understanding you're the one who's going to have to find out how far. Curtis showed up in April, 4 months before any of this came to a head, in the form of a phone call Dad took standing in the cider barn doorway while I happened to be visiting that same afternoon. And I watched his face go through something I'd never seen on it before. Somewhere between shock and a kind of hunger I didn't have a name for yet. His name was Curtis Malley, 39 years old, and the short version, which I only got in pieces over the following weeks, was this. His mother, a woman named Diane Malley, had a brief relationship with my father back in 1974, before he ever met my mother, and never told him she was pregnant. Diane raised Curtis alone, married someone else a few years later who never formally adopted him, and never once told her son who his biological father actually was. She died 14 months earlier, and going through her belongings, Curtis found a small bundle of letters in Dad's handwriting he didn't recognize, and a photograph on the back of which someone, presumably Diane, had written a single name. He took one of those mail-order DNA tests out of curiosity more than expectation, matched to a distant cousin on my father's side within a few weeks, and worked backward from there until he had a phone number. Dad cried on that phone call. I'd seen my father cry exactly twice in my life before that afternoon, once at my mother's funeral and once, briefly, the day I finished my certification exam, and here was a third time, standing in a cider barn holding a phone with a stranger's voice on the other end telling him he had a son he'd never known existed. I want to be honest about something here because it matters to everything that came after. I didn't distrust Curtis the moment I met him. He drove out the following weekend, nervous in a way that read as genuine, brought a framed copy of that photograph for Dad, sat at our kitchen table asking questions about Frank and the orchard and Lorraine like a man trying to fill in 39 years of a life he'd never had access to. He asked Hollies, our foreman, whether the old Baldwin trees near the fence line were the ones Frank had planted first, a detail he could only have gotten from those letters. And Hollies, who doesn't warm to strangers easily, warmed to him inside of 20 minutes. Dad lit up around him in a way I hadn't seen since before Mom died. And for the first few weeks, I told myself that whatever complicated feelings I had about a stranger walking into our family, this fast were mine to manage quietly, not his to apologize for. Aunt Marion, Dad's younger sister, met Curtis for the first time at a Sunday dinner in early May and spent most of the drive home, by her own later account, crying happy tears in the passenger seat, telling her husband she'd never thought she'd get a nephew at 70 years old. I understood the impulse. Losing Lorraine had left a specific kind of quiet in our family that none of us had figured out how to fill, and here was somebody offering to fill it warmly, without anyone having to ask. What I noticed slower, because I wasn't looking for it yet, was how quickly Curtis's visits started, including his wife, Brooke, and how quickly Brooke's questions at that same kitchen table stopped being about Frank or Lorraine and started drifting casually toward the acreage, the property lines, whether the orchard had ever been appraised, whether Dad had thought about what happens to the land someday. She asked all of it warmly, the way you'd ask about a subject you were only mildly curious about, and it took me embarrassingly long to notice that she was the only person at that table who ever steered the conversation there. There was a smaller thing too, a month or so in, that I let go at the time and have thought about more than once since. Dad mentioned, almost in passing, that he'd added Curtis as a second signer on the farm's small equipment maintenance account, the one that covers routine repairs and parts orders, nothing close to the operating accounts that actually mattered. Just so somebody else can sign for a tractor part if I'm laid up, he said, and it seemed harmless enough on its face, a father wanting his new son to feel useful. I didn't push back on it. I've wondered since whether not pushing back on that small thing taught Brooke something about how far she could go before anyone in this family drew a line. Curtis said something to me directly, the third or fourth visit, that I didn't understand the full weight of until much later. I'd asked him, gently, whether he and Dad had talked yet about updating any paperwork, thinking of nothing more complicated than making sure Dad's will reflected the fact that he now had 2 children instead of 1. Curtis put his hand on my shoulder, the exact gesture Dad used to use with me on the tractor, and said, "Blood finds its way home, Nora. I know this is fast for you, but it's not something you argue with." I remember thinking it sounded almost rehearsed, though I couldn't have told you why at the time, and I let it go the way I'd been letting things go all spring, because the alternative felt like punishing a man for the accident of his own timing. I brought it up with Curtis directly once more, alone, without Dad or Brooke in the room, a few weeks after that comment about paperwork. We were walking the front rows together, something Curtis had started doing on his visits, asking genuine questions about grafting and rootstock that made it hard to stay guarded around him. I told him plainly that I wasn't trying to make his arrival about property, that I just wanted us to handle anything official slowly enough that nobody down the road could second-guess it. He nodded, said that made sense, said he wasn't in any hurry about anything. I believed him when he said it. I still think most days that he believed it too in that specific moment standing in that row. Holly's noticed something the rest of us didn't that same month, though he didn't say anything about it until much later. He mentioned to me, almost offhand, that Brooke had asked him twice, on 2 separate visits, exactly how many acres sat behind the tree line that didn't get irrigated anymore. Holly's answered both times the way he'd answer any visitor, plainly and without suspicion, because 30 years on that land had never taught him to expect a question like that to be anything other than curiosity. He told me afterward he wished he'd mentioned it to me sooner. I told him there wasn't anything he could have known to flag at the time, and I meant it. A man appearing 40 years late isn't automatically a threat to anyone, but a threat rarely announces itself as one. It just gets a hand on your shoulder and a sentence that sounds like comfort and waits to see whether you push back. Brooke's occupation came up almost in passing, one Sunday afternoon in June, when she mentioned she worked in land acquisition, scouting rural parcels for renewable energy developers, mostly solar, sometimes wind, and that she'd actually driven past the orchard's back 40 on her way in that day and noticed it was flat, cleared, and close to a transmission line. She said it the way you'd mention weather. Dad, who genuinely didn't know any better, said something proud about how the back acreage hadn't been productive orchard ground in years anyway, half joking that somebody ought to find a use for it. Brooke smiled and changed the subject to dessert, and I remember thinking nothing of it at all, which is exactly the response she was counting on. What I know now, and didn't know then, is that Brooke had already run preliminary numbers on that property within 2 weeks of Curtis's first phone call, well before either of them had spent a single afternoon actually getting to know my father as a person rather than as 42 acres with good grid access. A regional solar developer called Meridian Solar Partners was actively acquiring rural land across 3 counties that year, offering long-term lease-to-own arrangements worth real money to landowners willing to sign. And Brooke had spent enough years in that business to recognize good acreage the way I recognize a forged signature, on site, before anybody else in the room understands what they're looking at. The number Meridian eventually put on the table once formal talks started was $2,180,000 over the life of the agreement, most of it front-loaded at signing once title cleared. That kind of number changes a person's math, and I don't think it's a coincidence that Curtis and Brooke's visits started increasing in frequency almost exactly when that figure did. Or that Curtis had, by early July, already put a deposit down on a truck he couldn't otherwise afford and started talking lightly about paying off some old credit card debt, once a few things sorted themselves out. Recognizing an opportunity isn't a crime. What somebody does with that recognition, quietly, while the person who actually owns the land is still learning their new son's name, is a different question entirely. The catheterization was scheduled for a Tuesday morning in late July, an outpatient procedure at County General's cardiac lab, routine enough that Dad's cardiologist described the risk as minimal and the recovery as same day. I drove him and myself at 6 that morning, the two of us mostly quiet on the drive, Dad joking once, thin but genuine, that he'd rather be pruning trees in the dark than sitting in a paper gown. I sat with him through the pre-op paperwork, watched a nurse start his IV, and left around 9 once he was prepped and sedated, because the lab didn't allow family in the procedure room itself, and I had a deposition scheduled that same afternoon on an unrelated case I couldn't reschedule twice without burning a colleague's goodwill. Curtis called me around 10, said he and Brooke happened to be in the area and wanted to swing by the hospital to sit with Dad through recovery so he wouldn't be alone when he came out of sedation, since I'd already mentioned my deposition to him the week before. I remember being genuinely grateful for that call. I thanked him for it, told him it meant more to me than he probably realized. I want that on the record because everything I did after this point started from a place of thinking I'd been shown real kindness that morning, not the opening move of anything. The procedure itself went fine, a minor blockage identified, nothing requiring immediate intervention beyond a medication adjustment. Dad was moved to recovery around 1, and the discharge nurse's log, which I'd end up reading line by line weeks later, shows exactly what conscious sedation recovery looks like on paper. Blood pressure checks every 15 minutes, a note at 2:10 that the patient was groggy, oriented to person but intermittently confused on time and place, and a standard verbal and written instruction, given to every patient in that unit and signed for by Curtis as the accompanying adult, not to sign any legal or financial documents, drive, or make significant decisions for 24 hours following sedation. Because judgment and memory formation stay measurably impaired for hours after a patient feels more or less back to normal. Dad was formally discharged at 3:52 that afternoon, wheelchaired to the pickup curb, still listed on the chart as mildly disoriented. Curtis drove him home. I finished my deposition around 4, texted Curtis to check in, and got back a single line. "All good, he's resting, talk tomorrow." I didn't think anything of the brevity of it. I had a 2-hour drive of my own ahead of me and a stack of case files waiting. What happened at the farmhouse that same afternoon, I only pieced together later, but the shape of it is this. A woman named Yolanda Pierce, a mobile notary Brooke found through a gigwork app that connects notaries with clients who need signings done outside an office, arrived at the property with a single-page quitclaim deed already drafted. The kind of document that transfers whatever ownership interest a person holds in real property to someone else, with almost none of the protections a full warranty deed would carry. The deed named Curtis as sole grantee, Gerald Kessler as sole grantor. Notarized according to the jurat stamped at the bottom of the page in person at the Orchard farmhouse at 3:15 that afternoon, 37 minutes before the hospital's own paperwork says my father was medically cleared to leave the building. Curtis told Dad, gently, that it was just paperwork to simplify things, a way to make sure the family didn't end up in a mess down the road the way some families do, that Nora wouldn't need to be bothered with the boring administrative side of it since she had her own busy career, and that this was exactly the kind of thing a person did to keep things simple once they finally had more than one child to think about. Dad, still fuzzy from sedation, feeling closer to his new son than he'd felt to almost anyone since Lorraine died, signed it. He didn't understand what he was signing. I believe that completely, and I believed it the moment I first heard him describe the afternoon to me, weeks later, in a voice that still sounded confused about what had actually happened in his own kitchen. I didn't cry when I found out what that afternoon actually was. I opened a case file instead, the way I open every one, and I started with the one date that couldn't lie to me. The first thread came loose almost by accident, 10 days after the procedure, on a phone call from Holly's Fenwick, who's run the Orchard's day-to-day operations for 30 years and has known me since I was 14. Holly's called on a Thursday evening, his voice tighter than I'd ever heard it, to tell me that 2 men in button-down shirts had shown up that morning with a soil testing rig and a clipboard, walking the back 40 with a level of confidence that told him they weren't asking permission. They were confirming a plan. When Holly's asked what they were doing, one of them told him they were running a preliminary site assessment for Meridian Solar Partners, and that Curtis had authorized full access as the new owner. I didn't like the sound of that word one bit, Holly's told me. Your dad's never once used it about anybody but himself. Holly's knew, the way a man who's worked a piece of land for 30 years just knows, that something was deeply wrong with that sentence. He didn't call Curtis, he called me. I drove to the county's Register of Deeds office the next morning, not entirely sure what I was looking for, only that I needed to see whether any paperwork had actually moved on that property recently. The clerk who helped me, a man named Dale Whitcomb who'd clearly walked plenty of nervous family members through this exact kind of search before, pulled up a pending submission in the county's e-recording queue. A quitclaim deed submitted for recording 6 days earlier, sitting in the standard review backlog most counties run before a document formally posts to the public record. Dale told me matter-of-factly that the average processing time that summer was running about 10 business days given staffing shortages, which meant this one had roughly 4 business days left before it would post permanently and become, in the eyes of the county, simply the truth. I read the notary jurat on that pending deed standing at his counter, and something in the specific language of it stopped me before I'd even finished the sentence. It stated that Yolanda Pierce, notary public, personally appeared before Gerald Kessler and witnessed his signature at the property address, in person, at 3:15 p.m. on the date of the procedure. I'm a notary myself, commissioned in this state for exactly the reason most document examiners are, and I know the personal appearance requirement the way I know my own name. A notary's certification isn't decoration on a signature. It's a sworn statement under penalty of perjury that a specific human being stood in front of another specific human being at a specific place and time. It can be wrong by accident. It is far more often wrong because somebody needed it to say something that didn't actually happen. I called County General's Medical Records Department that same afternoon, and with Dad's own signature on a release, since he was fully willing to help once I explained why I was asking, I had his full discharge log in my hands within 2 days. It told me exactly what I already suspected standing at Dale's counter. At 3:15 that afternoon, the moment Yolanda Pierce's jurat swore she was standing in my father's kitchen watching him sign, the hospital's own nursing staff had him seated in a recovery bay, blood pressure cuff still on his arm, 37 minutes from being medically cleared to leave the building, 52 minutes by car from the orchard. A person cannot be in 2 places at once. That's not a legal argument. It's arithmetic, and arithmetic doesn't care whose signature is on the deed. I sat in my car in the hospital parking garage after picking up that discharge log and read it 3 times before I trusted what I was looking at, which is exactly what I do with any questioned document that turns out to be exactly as bad as I'd feared. I called a woman named Doris Kowalczyk that same evening, the examiner who'd trained me 20 years earlier and still took my calls when a case got personal enough that I needed somebody outside my own head. I told her the whole thing, the letters, the DNA test, the deed, the 37-minute gap. She was quiet for a second before she said something I've carried since. The paperwork always tells you who somebody actually is, she said. It just usually waits until they think nobody's checking. She didn't tell me what to do next. She didn't need to. I already knew. I didn't call Curtis that night. I called Owen Bramlett instead, an attorney a colleague had used 2 years earlier on a similar case, and told him everything in about 20 minutes flat, my voice steadier than I actually felt. Owen asked me one question before anything else: had the deed finished recording yet? I told him it had roughly 4 business days left in the review queue. He told me that gap was the entire case, fixable, but only if we moved immediately. A signature on a page tells you what someone wanted a document to say happened. A hospital's own clock, kept by people with no reason to lie, tells you what actually did. Owen laid out the mechanics for me that same evening, in the plain language I badly needed after a day spent staring at a jurat that swore to something arithmetic already disproved. A pending recording could be flagged with the Register of Deeds office directly, requesting an administrative hold based on a sworn allegation of fraudulent notarization, which Dale's office had discretion to grant while a court reviewed the underlying claim. Separately, we'd need a civil petition asking a judge for a temporary restraining order preventing any transfer, sale, lease, or encumbrance of the property, and a formal notice of lease pendens recorded against the parcel itself, which puts the whole world on notice that ownership is legally contested the moment anyone else searches the title, including, critically, Meridian Solar's own closing attorneys. The recording hold buys you days, Owen told me. The lease pendens buys you the rest of the case. He also told me something I hadn't fully considered. Even if the deed had already finished posting before we got the hold in place, none of it would matter for the underlying claim, because a document built on a false notarization is void from the moment it's signed, not merely voidable later. The hold wasn't about saving the case. It was about saving Meridian's closing date from finishing before a judge ever got the chance to look at it. I drove back to Dale Whitcomb's counter myself the next morning rather than let it happen entirely through Owen's office, because 12 years of chasing paper trails had taught me I wanted to watch this one go in with my own eyes. Dale took the sworn allegation and the discharge log copy without a flicker of surprise, the practiced calm of someone who'd seen this exact shape of family before, under different names. Most people who come through that door already missed the window, he told me, sliding a receipt copy back across the counter. You didn't. That's rarer than you'd think. He flagged the submission for administrative hold that same afternoon, effective immediately, freezing it in the queue exactly where it sat. Owen filed the emergency petition, and the Lees pendants the following morning. A judge granted the temporary restraining order that same day, no notice required to the other side given the documented urgency. And I picked up the signed order from Owen's office at 4:40 that afternoon, 20 minutes before it would have stopped mattering if Meridian's closing had somehow moved faster than we did. $2,180,000 was still sitting on the other side of that queue the whole time I drove to pick it up. And I remember thinking, more than once on that drive, that a piece of paper in a folder on my passenger seat was the only thing standing between my father and losing land 3 generations of his own family had cleared by hand. If somebody in your own family has ever tried to move something that fast while the person it actually belonged to was still recovering in a hospital bed, tell me in the comments, because I want to know how you caught it. And if you want to see whether 4 business days of queue time was actually enough, hit subscribe now, because the closing date still hadn't arrived yet. Meridian Solar's site team had scheduled their final pre-closing walkthrough for the following Tuesday, the same day their acquisitions director was flying in from out of state specifically to sign off on the parcel, and Curtis had told Hollies to expect them by 9. I was standing at the edge of the back 40 at 8:45 with Owen's signed order in a folder under my arm when their truck pulled up the drive, Curtis walking out to meet it before I'd even gotten out of my car. He read the first paragraph of that order and looked up at me with an expression I hadn't seen on him before, somewhere between disbelief and the specific kind of anger that shows up when a plan stops working exactly on schedule. You didn't have to do this, he said. This is family, we would have worked something out for you. I told him I hadn't gone around the family. I'd gone to a judge in the open, with a document that actually said what happened. Brooke arrived 4 minutes later, in time to watch Meridian's site team standing around a parcel they suddenly couldn't touch, and her face did something calculating before it did anything else. The way a person's face moves when they're already 3 steps ahead into damage control rather than still processing what just happened. This is going to blow up the whole deal, she said, more to Curtis than to me, which told me plenty about where her priorities actually sat. Meridian's acquisitions director, a woman I never got a name for, read the order over Curtis's shoulder, said something short and clipped into her phone, and had her team back in the truck within 10 minutes. The kind of speed that told me this wasn't the first contested parcel her company had ever walked away from. One of her site technicians, folding up a tripod on his way past me, muttered that this made the 3rd property that quarter where a family member had shown up with paperwork nobody on the seller's side had mentioned existed, which told me plenty about how routine this particular kind of quiet theft actually is. Not just in my family, in plenty of others nobody happens to be filming. Dad came out onto the porch partway through, still moving carefully from the procedure, confused by the truck and the strangers and the tension he could clearly feel even without understanding its source yet. He asked me quietly if everything was all right. I told him it would be, and for the first time in 11 days that wasn't even a lie I was telling to protect him from something. I didn't raise my voice at either of them. I called Hollies over to witness Meridian's team packing back into their truck empty-handed, and I wrote the time down in the notebook I still carry out of 12 years of habit, the same notebook I use to log the exact minute I pull a questioned document out of an evidence envelope. Stopping a closing in a driveway isn't dramatic. It's the least dramatic thing you can do, and it's the only thing that actually holds up once a judge starts reading the file. The 3 weeks after that were quieter on the surface and considerably louder underneath, which in hindsight should have told me something was still moving somewhere I couldn't see yet. Brooke stopped calling me directly and started calling Aunt Marion instead, feeding her a version where I'd humiliated a grieving family in front of strangers over a piece of land nobody was using anyway, where I was the jealous only child who couldn't stand sharing an inheritance. Marion called me herself, upset, repeating a phrase almost word for word that Brooke had apparently used at a lunch that week, that I was punishing an innocent man for a mistake his own mother made 40 years ago. I told her the mistake wasn't Curtis existing. The mistake was a deed notarized at a time our own father's hospital records prove he wasn't even in the building where it supposedly happened. And I could hear her go quiet on the line, doing the math for herself for the first time. My cousin Priya, Marion's daughter, called a few days after that, having heard a version secondhand at a birthday dinner where Brooke wasn't even present. Something about me hiring some fraud expert friend to invalidate a signature out of spite. I told her the fraud expert was me, that I hadn't hired anyone, and that the discharge log had come from the hospital's own records department, not from anything I could have manufactured even if I'd wanted to. She went quiet the same way Marion had, recalculating in real time. Curtis asked me to meet him alone, without Brooke, at a diner halfway between our two houses about 2 weeks before the hearing. I almost said no. I went anyway, mostly out of some stubborn hope that the man I'd walked the front rows with in April was still in there somewhere, separate from whatever Brooke had built around him since. He didn't apologize, not directly, but he asked me more than once whether I thought Dad would ever forgive him, in a voice that sounded genuinely uncertain of the answer rather than performing for an audience. I told him that wasn't a question I could answer for our father, and that the only thing inside my control was making sure whatever happened next happened with real paperwork, instead of a jurat that lied about where anybody was standing. He didn't touch his coffee the whole time we sat there. I paid for both cups on my way out, which felt, at the time, like the last soft thing I had left to offer him before the hearing made everything harder between us. Brooke tried one more direct approach about 10 days before the hearing, calling me herself for the first time since the driveway, her voice pitched somewhere between reasonable and pleading. She suggested we could all still work something out. A partial lease maybe, everyone getting a share, no need for a courtroom. I told her a partial lease built on a fraudulent deed was still built on a fraudulent deed, and that the only workable arrangement at this point ran through a judge, not a phone call. She didn't call again after that. Owen's office subpoenaed Brooke's phone records as part of the emergency petition, a routine step once fraud is formally alleged, and what came back 3 weeks later filled 9 pages. Most of it damning in ways I hadn't fully anticipated even having lived the whole thing. A text from Brooke to Yolanda Pierce sent 2 days before the procedure read, "Just need the jurat to say she was physically present at the house. Nobody checks these unless something goes wrong." Yolanda's reply sent 4 minutes later. "Understood, same rate as discussed." And a text from Brooke to Curtis sent the morning of the procedure itself, the one I've thought about more than almost anything else since. She won't find out until it's recorded. Once it's recorded, it's basically impossible to unwind. Just get him to rest after, we'll swing by at 3. I read that last one standing in Dad's kitchen, the same kitchen where he'd signed a deed he never actually understood, and I felt something harden in me that hadn't fully hardened until that exact sentence. 12 years of examining other people's fraud for a living, and it turns out reading your own family's version of it in plain text still lands differently than any case file ever had. I called Doris again that same night, mostly just to say the words out loud to somebody who'd understand them the way I did. "The ones who plan it out in writing," she told me, "never think the writing is going to be the thing that catches them. They think the plan is the smart part. The texts are just logistics to them." I sat with that a while, my father's kitchen quiet around me, and let it be true. My friend Alina came by that same week, the kind of friend who shows up with takeout instead of asking whether you want company first, and sat with me at that same kitchen table while I walked her through 9 pages of somebody else's texts. She'd watched her own brother go through a guardianship fight over their mother a few years back, and didn't sugarcoat what she thought this was going to cost me. "You're going to spend the next few months wondering if you're the villain in somebody else's version of this," she said, "and I need you to hear me say right now that you're not, because there's a week coming where you'll forget." She was right about the week. It came almost exactly when Priya's phone call did, and I thought about that kitchen table more than once to get through it. Owen also had his own investigator pull Yolanda Pierce's physical notary journal, The bound, sequentially numbered log every notary in this state is legally required to keep for every signing performed, regardless of whatever a phone app might also track. State law requires an entry for each notarization: date, time, type of document, and crucially, the signer's own thumbprint or a witnessed signature line taken at the moment of the appearance itself. Yolanda's journal entry for that afternoon existed, filled in with the same 3:15 p.m. timestamp as the deed's jurat, but the signature line meant to be completed in Jerry's own hand at the moment of signing was blank, initialed later, she claimed, because she'd been running behind that day and filled the journal in from memory that evening. A notary journal completed after the fact from memory for the one signing that happened to be worth $2 million was not the kind of coincidence Owen had any trouble explaining to a judge. Once we had those texts in hand, Yolanda Pierce's own mobile notary app worked against her almost immediately. The app logs mileage automatically for tax purposes, every trip time-stamped and geolocated, and her account showed no trip anywhere near the orchard that entire afternoon. Her actual location data placed her 22 miles away, at a different signing appointment entirely, at the exact minute her own jurat swore she was standing in my father's kitchen. A phrase somebody uses to talk you out of checking usually isn't reassurance. It's a confession, dressed carefully enough that most people never bother reading it twice. The hearing itself landed 6 weeks after the procedure, in a courtroom that smelled like every county building I'd ever sat in, waiting on someone else's paperwork, fluorescent light overhead, and a docket taped to the door listing 3 other property disputes above ours. Owen and I got there 30 minutes early and sat in a hallway lined with the same molded plastic chairs every government building in the county seemed to order from the same catalog. Curtis and Brooke arrived with their own attorney 20 minutes later, and none of us acknowledged each other beyond a nod. Judge Priscilla Holt had read the full file before we walked in: the discharge log, the notary's own mileage data, Brooke's texts, and Owen's timeline, laying the whole sequence out in a single afternoon of exhibits. She asked us to be seated and moved through the docket with the brisk economy of someone who'd already made up most of her mind and was giving both sides a fair chance to change it. Holly's testified first, plainly, about the soil testing crew and Curtis's claim of ownership before any deed had even finished recording. "Your father built that word into every fence post on the property," he told the judge when asked how he knew ownership mattered to Jerry specifically. "Nobody uses it loosely around him." Dale Whitcomb testified about the recording queue and the standard 10-day processing window, closing off any argument that the fraud had somehow slipped through faster than it actually had. Aunt Marion testified next, called reluctantly by Owen once Brooke's own attorney listed her as a supporting witness for the defense, and under a few careful questions she ended up describing, almost against her own intention, the exact phrase Brooke had fed her at that lunch weeks earlier, the one about an innocent man being punished for his mother's 40-year-old mistake. Asked directly whether she still believed that characterization once she'd seen the discharge log herself, Marion said no, plainly, and looked at me across the courtroom in a way that told me the apology she'd give me afterward would be a real one. Owen called Yolanda Pierce herself, who, faced with her own app's mileage log entered as an exhibit, admitted under oath that she'd never physically been at the property that day. That Brooke had described the situation as the family already agreed it's just a formality, and that she'd notarized the document remotely off a photograph Brooke sent her, believing or claiming to believe that it was a minor procedural shortcut rather than what it actually was, a felony false certification. Brooke's attorney tried to characterize Yolanda as an independent bad actor, unconnected to his client's knowledge, until Owen read the text about the jurat language back into the record slowly and let the silence after it do the rest of the work. Dad testified last, and I watched him do it with more clarity than I expected given how nervous he'd been the night before. He didn't dispute signing something. He said plainly that he remembered feeling foggy that whole afternoon, that he remembered Curtis's voice more than his face, and that he had no memory at all, none, of a woman standing in his kitchen with a notary stamp. "I know I signed my name to something," he told the judge. "I don't know what I signed. I was still seeing double." Brooks' attorney tried, gently, to suggest his memory simply wasn't reliable given his age, and Judge Holt asked, without much patience left in her voice, whether the defense was arguing my father's memory was unreliable or that the hospital's own time-stamped clinical records were, since one of those two things had a nursing staff's initials on every 15-minute entry and the other did not. She asked Curtis directly why he'd arranged for a deed transfer the same afternoon of his father's sedated discharge rather than waiting even one day, the way the hospital's own written discharge instructions explicitly required, instructions he'd signed for himself as the accompanying adult. Curtis said he hadn't known that detail mattered, that Brooke had handled the logistics. The judge asked whether he'd read the discharge paperwork himself before the notary arrived. He admitted he hadn't, and for a moment, watching his face, I believed that admission cost him something real. Brooks' attorney cross-examined me directly, briefly, trying to suggest that my professional training made me predisposed to see fraud in an ordinary family transaction, the same way a hammer sees every problem as a nail. I told him a discharge log with a nursing staff's initials on it isn't a hammer looking for a nail. It's a timestamp, and a timestamp doesn't change meaning depending on who happens to be reading it. He didn't have a follow-up question after that, and Judge Holt moved the proceeding along without comment. Closing arguments took another 20 minutes. Owen walked the judge through the timeline one final time, the discharge log against the jurat, the mileage data against the claimed appearance, the text that named a time, and a plan 2 days before anyone had reason to send it if the signing was really as simple as Curtis kept insisting it was. Brooks' attorney argued mostly that his clients had acted out of a genuine, if clumsy, desire to help an aging man simplify his affairs, and that the timing was unfortunate rather than deliberate. Judge Holt didn't seem moved by that and said so before she moved to the ruling, noting that a text describing exactly how to avoid getting caught wasn't the language of somebody trying to help. The ruling took about 20 minutes to deliver, though it felt considerably longer sitting there listening to it. The deed was void for defective notarization, given a jurat that swore to a personal appearance which never occurred, and separately void on the basis of undue influence, given a signing that took place inside a documented window of impaired capacity that the hospital had explicitly warned against in writing. Full title restored to my father, immediately and permanently. The lease pendens made permanent against any future transfer without independent legal review. Yolanda Pierce's notary conduct was referred to the Secretary of State's Licensing Division for revocation and to the District Attorney's Office for a fraud referral, a process that concluded a few months later with her commission permanently revoked and a criminal charge for false certification still pending as of this recording. Curtis and Brooke were ordered to personally repay the $85,000 deposit Curtis had already drawn from Meridian's exclusivity agreement and largely spent, since that agreement depended entirely on a deed the court had just declared never legally existed, and to cover the full cost of Dad's legal fees. Dad and I sat in his kitchen the evening after the ruling, the two of us alone for the first time since the whole thing had started, and he asked me, quietly, whether he'd been a fool for signing anything at all that afternoon. I told him a man coming out of sedation isn't a fool for trusting the people standing closest to his bed, that the fault sits entirely with whoever built a document specifically to be signed inside that window, not with the man who couldn't have known better in it. He nodded slowly, the way he used to nod at a row that needed more work than he'd hoped, and told me he was glad, at least, that the daughter who'd caught it was the same one who'd learned to read a bricks meter standing next to him 30 years earlier. I didn't have anything to say back to that. I just sat with him a while, the kitchen quiet, the way it had been quiet the night I first read Brooke's texts, except this time the quiet felt earned instead of heavy. A ruling doesn't undo an afternoon a father can't fully remember. It only makes sure somebody finally reads the actual clock out loud, in a room where lying about it costs something real. Brooke's attorney filed a motion to reconsider about a month later, arguing that Yolanda's mileage app could have malfunctioned that specific afternoon, a claim that fell apart the moment Owen produced 3 additional entries from the same day showing the app working correctly on either side of the disputed window. Judge Holt denied it in writing within 2 weeks, noting dryly that an app malfunctioning exactly once, for exactly the 40 minutes in question, and functioning normally immediately before and after, asked more of coincidence than any court reasonably could accept. Filing that motion cost Curtis and Brooke another few $1,000s in legal fees nobody made them spend. It's been 4 months now since that hearing, and I want to be honest about how this actually settled, because it isn't the kind of ending where everybody hugs it out over cider at the tasting room and Sunday visits go back to normal. Curtis and Dad still talk, though differently now, shorter calls, no more unsupervised afternoons, nothing involving paperwork that doesn't go through Owen's office first. I don't think Curtis set out that first phone call in the cider barn doorway to defraud a father he'd just found. I think he got pulled along by someone who saw an opportunity faster and more clearly than he did, and didn't have it in him to say no once the money got real enough. That doesn't make what he let happen any less costly to the man who trusted him. It just means Dad's still deciding, slowly, how much of a relationship with his son he's willing to rebuild on his own terms this time at his own pace. Brooke's real estate license is currently under review by the state board, once the fraud finding became part of the public record, and the last I heard, Meridian Solar has quietly moved on to another parcel 2 counties over. I don't feel much of anything about that, honestly, beyond a kind of tired relief that it's no longer sitting on our land waiting to close. The $85,000 Curtis had already spent turned out to be money he didn't actually have sitting anywhere convenient. And repaying it under the court's order meant refinancing the truck he'd bought on the strength of a deal that never should have existed in the first place, on worse terms than the original loan, plus the legal fees on top of it. I didn't take any satisfaction in hearing that secondhand from Marion. I also didn't feel obligated to feel sorry about it, which is its own kind of resolution, quieter than either anger or forgiveness. Aunt Marion calls every week now, mostly just to talk, which she never used to do, and I think we both understand what those calls are actually about without either of us needing to say it out loud. Priya sent me a short apology text a few weeks after the ruling about repeating things she'd heard secondhand without checking them first. I believe she meant it. Going through Dad's desk drawer a few weeks after the hearing, helping him sort through what paperwork to keep and what to finally shred, I found a small bundle of letters tied with twine, addressed to Diane, dated across 4 months in 1974, every one of them stamped but never mailed. He'd written to her after she moved away, apparently, and lost his nerve every single time before he got to the mailbox. He didn't know until I handed him that bundle that any part of that story had survived at all. He sat with them a long time before he said anything, turning the top envelope over in his hands the way he used to turn a piece of fruit to check it from every angle. And what he finally said was that he wasn't sorry Curtis had found him, only sorry it took a stranger's DNA test and 40 years of silence to make it happen. He let me read the top one, dated March of that year, 4 lines long and handwriting shakier with youth than the version I knew. I keep thinking about the orchard in spring and whether you'd have liked it. I don't know how to say the rest of what I mean, so I'm not going to try today. I understood that better than I expected to, once I'd read it myself, a man 22 years old already practicing the same restraint he'd carry for the next 5 decades, right up until a phone call in a cider barn doorway finally broke it open. Dad worked with Owen afterward to set up a revocable living trust holding the orchard outright, naming me as successor trustee, which means no single signature, sedated or otherwise, notarized by anyone, real or invented, can ever move that land again without a second set of eyes on it first. I go out most weekends still, coffee in hand, walking the same rows I learned to read before I could read anything else. And Dad started talking cautiously about leasing that unused back 40 properly on our own terms. To a smaller developer at a fair number the whole family actually agrees on together, which feels like the version of that conversation Brooke tried to steal from us in the first place, given back the right way. I've also started putting my own paperwork in order, something I'd put off for years longer than a person in my profession really has an excuse for. My own power of attorney documents now name 2 people jointly rather than one, with language that requires both signatures for anything involving real property. specifically so that no single relationship, however sudden or however warm it feels in the moment, could ever move fast on my own behalf the way Brooke moved on Dad's. I didn't need a lecture to get there. I'd already lived through the reason. I drove Dad out to the back 40 myself 2 Sundays ago. No particular reason for it beyond wanting him to see it under a sky that wasn't full of surveyors and clipboards. He stood at the fence line for a long minute, the same way he used to check a row for blight, and told me the ground still looked like good ground to him, whatever anybody eventually decided to do with it. I told him it was his to decide all of it on his own timeline. He didn't ask what would have happened if I hadn't caught the timestamp in time. I didn't bring it up either. Some things in a family are allowed to stay unspoken once the paperwork's already said everything that needed saying. Christmas landed a few months after the ruling, the first since all of this had settled into whatever shape it was going to permanently take. And Dad wanted the tasting room decorated the way Mom always did it. Garland along the walnut counter, the same ceramic tree she'd bought the year I was born plugged in by the register. He asked whether I thought it would be strange to invite Curtis, just for an afternoon, no Brooke, nothing about the orchard on the table. I told him it wasn't my relationship to manage, only mine to respect, and that if he wanted to try it slowly, I'd be there too, close enough to make sure slowly stayed the operative word. Curtis came for 2 hours, quieter than I remembered him being back in April, and left before dinner. Dad walked him out to his car alone, and I didn't ask what they said to each other. Some conversations in a family are allowed to stay between the two people having them, even when one of those people is still deciding how much trust he's willing to extend a second time. Harvest came in again this September, the way it does every year regardless of what a family's been through in the meantime. And I ran the bin truck myself for the first 2 days because Dad's cardiologist still wants him sitting more than standing through a full picking day. Follow-up appointments every 6 weeks now. Nothing urgent, just careful. Holly's ran the crew schedule same as always. Curtis wasn't there. I don't know yet whether he will be next year or the year after, whether whatever's left of that relationship ever grows back into something that fits comfortably at a harvest table. Dad still keeps a place set for the idea of it, the way he used to keep 2 coffee cups out of habit, and I've stopped telling him not to. Curtis told me once on one of those shorter, more careful calls that blood finds its way home, that it wasn't something I should have argued with using paperwork. I told him he wasn't wrong about the first part. Blood did find its way home. It just came with a subpoena attached, and it found its way to a courtroom before it ever found its way back to a kitchen table. That's my story. A discharge log that couldn't lie, a notary's mileage app that couldn't either, and a $2,180,000 deed that a judge unwound in 20 minutes once somebody finally checked the actual time on the actual clock. If you've ever caught somebody trying to move fast on a parent's property while that parent wasn't even fully awake yet, tell me what you did about it in the comments. I read every one of them. Check out my latest video and hit subscribe for more.